Hello and welcome. If you're a law student or prepping for the bar, you're in exactly the right place. Today, we're digging deep into the very foundation of Philippine environmental law, which is, of course, the Constitution. Now, this is about so much more than just nature. We're talking about our national identity, our sovereign rights, and the legal framework that's supposed to protect our national heritage. So let's get right into it.
So let's start with the big question that frames our entire discussion. How does our Constitution actually, protect our environment? Is it just a bunch of nice-sounding words, or does it have some real legal muscle? Well, that's exactly what we're going to figure out today. Here's how we're going to tackle this. We'll start big by defining our national territory. Then we'll dive into the super relevant West Philippine Sea dispute. From there, we'll get into a core legal principle, state ownership of natural resources, and importantly, its exceptions. And we'll finish up with the powerful right to a healthful ecology. Oh, and definitely stick around for the end, where we'll wrap up all the key takeaways, perfect for your exam review. All right, first things first, our national territory. I love this subtitle here, mapping our environmental patrimony. It really hits the nail on the head, because think about it. Before you can protect something, you've got to know exactly where its borders are, both legally and physically. So, Article 1 of the Constitution lays it all out for us. It defines our territory as the Philippine archipelago. And here's the crucial part. It includes not just our thousands of islands, but also the waters around, between, and connecting them. This is the heart of the archipelagic doctrine. The definition also extends to any other territories where we have sovereignty or jurisdiction. So what does that mean in simple terms? It means everything: the land, the air, the rivers, the sea, all the way down to the seabed and what's underneath it. It's the whole package.
Now, here's where it gets really interesting, because international law actually expands on this. Under the UN Convention on the Law of the Sea, or UNCLOS, we have different maritime zones. The one you absolutely have to remember for environmental law is the 200 nautical mile exclusive economic zone, the EEZ. Why? Because this is the area where our Constitution says the state must protect the nation's marine wealth and reserve its use exclusively to Filipino citizens. This entire legal framework, by the way, was upheld by our Supreme Court in the case of Magallana v. Executive Secretary.
And that EEZ? Well, it leads us straight into one of the most critical issues of our time, the West Philippine Sea dispute. This isn't just some abstract geopolitical argument. It is a real-time battle for our environment and our economy. So let's break down the competing claims. The Philippines' position is really straightforward. It's based on international law, specifically UNCLOS. Our claim is measured from our legal baselines. China's claim, on the other hand, is based on a vague concept of historical rights, represented by their so-called 9-dash line. And the problem with that line? It carves out a massive piece of the sea, encroaching on about 80% of our exclusive economic zone. This conflict is what pushed the Philippines to bring a case against China. And in 2016, we won. We won big. The arbitral tribunal at The Hague was crystal clear. It declared that the 9-dash line has absolutely no legal basis. It found that China had violated our sovereign rights by messing with our fishing and our oil exploration. And this is huge for environmental law. The tribunal explicitly called out China's island building, stating that it caused severe, irreversible harm to the marine environment, wiping out acres and acres of precious coral reefs. But let's be real, how do you actually enforce a ruling like that? There's no world police to call. The real power here is in world opinion. And as Justice Carpio beautifully put it, a nation doesn't become a leader through sheer force. It earns respect by following the rule of law. Okay, so we've mapped out our territory. Now let's pivot to a really fundamental question of property law. Who actually owns all the natural resources inside that territory? The answer comes from something called the Regalian Doctrine, a legal concept we inherited from Spain. So, this is the Regalian Doctrine, also known as jure regalia. Simply put, it means that the state is the original owner of everything, all public lands, waters, minerals, you name it. So if you or I want to claim private ownership of a piece of land, we have to be able to trace our title back to a grant from the state. The case of Ocho versus Director of Lands is a perfect example. In that case, a non-Filipino tried to register land his family had occupied since 1880. The court said no, because he couldn't show a grant from the state. And since he wasn't a Filipino citizen, the land was still considered part of the public domain. But, like any good rule in law, the Regalian Doctrine has a major exception. And this exception recognizes a right that existed long before the Spanish ever set foot here. This powerful quote comes from a landmark 1909 case, Carino v. Insular Government. So what happened here? Mateo Carino, who was an Igorot, tried to register his ancestral land. The colonial government denied him, saying he didn't have a formal title from Spain. The question for the U.S. Supreme Court was this: was land held since time immemorial part of the public domain? The court's answer was revolutionary. They said that if a community has held land since before anyone can remember, that land was never public land to begin with. It was always private. And that's the doctrine of native title.
That historic Carino doctrine is now the backbone of Republic Act 8371, the Indigenous Peoples' Rights Act, or IPRA. This law formally recognizes ancestral domains as the private communal property of indigenous cultural communities. Now, IPRA's constitutionality was challenged in the case of Cruz v. NCIP. The Supreme Court ended up in a tie vote, and because of that tie, the petition to strike down the law was dismissed. The practical effect? IPRA was upheld, and with it, these fundamental indigenous rights.
Now let's talk about a more modern limitation, and this one is a classic bar exam topic. What's the deal with new land, like land reclaimed from the sea? The case you need to know is Chavez versus Public Estates Authority. The government wanted to sell a huge chunk of reclaimed land in Manila Bay to a private corporation. The Supreme Court put a stop to it. The ruling was clear on two things. First, reclaimed lands are public lands. Second, the Constitution is explicit that private corporations are not allowed to own these kinds of lands. They can only lease them. So the sale was declared void. All right, we've covered territory and we've covered ownership. Now we get to the very heart of the matter, the constitutional right that serves as the legal sword for every single Filipino who wants to protect our environment. Article 2, Section 16. Burn this into your memory. This is not just a nice suggestion or a state policy. The Supreme Court has repeatedly said this is a fundamental, enforceable, legal right. It's a direct command to the state to protect our environment, not just for people, but in accord with the rhythm and harmony of nature itself. It's beautiful, really. And speaking of this, right, you absolutely cannot discuss it without talking about the celebrated case of Oposa versus Factoran. The facts are iconic. A group of miners, actual kids, sued the Secretary of Environment and Natural Resources to stop him from issuing more timber licenses. And get this, they sued on behalf of themselves and for generations yet to be born. The government argued they had no right to sue, no locus standi. Well, the Supreme Court's ruling was nothing short of groundbreaking. It established three key doctrines. One, the miners did have the right to sue based on the concept of intergenerational responsibility. Two, the right to a healthful ecology is a real, justiciable right that you can fight for in court. And three, the state, using its police power, can absolutely cancel things like logging permits to protect that right. Okay, we have covered a ton of ground, so let's pull it all together in a quick, high-yield summary. Think of this next slide as your ultimate cheat sheet for the bar.
Here it is, all in one place. Our national territory is defined by the Constitution and UN Close, and it's affirmed in Magalona. Our maritime rights in the West Philippine Sea, backed by the 2016 Hague ruling. The general rule on ownership is the Regalian Doctrine, shown in Okcho. The huge exception to that is native title, born from the Carino case. The right to a healthful ecology is a real, enforceable right, thanks to Oposa. And a crucial modern limit is that corporations can't own reclaimed public land, as decided in Chavez.
So we end right back where we started. The Constitution gives us this incredibly powerful legal framework. The laws are on the books, and the landmark cases have been won. But I want to leave you with this final thought. Facing today's challenges, from climate change to intense geopolitical pressures, are these constitutional safeguards by themselves truly enough? Thanks for joining this explainer.